Hi, I'm Bobby Feisee, attorney with Insight Law, and this educational topic is on how to maintain your lifetime protective trust. So the first thing you understand is there is a tremendous amount of protections with those assets that are in the lifetime protective trust, or our clients call them school bus trusts. As a refresher or review, during the client's lifetime, it's an open bucket, and after they pass away, you can close the bucket and the assets can be accessible, and so you just need to understand the assets can be accessible to the beneficiaries, but we can keep them away from the creditors and predators of this world. So you have to understand that there is a little bit of maintenance that needs to be done. It's not onerous, but there are steps that we have to do on an annual basis so that if that major event does happen, lawsuit, divorce, those types of things, and the attorneys come circling, that we can present the file and show that we've actually been running the trust as a separate entity. It's a similar concept in the corporate law called piercing the corporate veil, where people have these LLCs or entities, but they're not really running them the right way. So the basic idea behind it is that a lot of times clients will leave their assets in trust for their beneficiaries. The beneficiaries will be the trustees or the ones managing those trust assets. Now, if the beneficiary was the sole trustee and sole beneficiary of that asset, the way that creditor protection is not as strong that if the beneficiary had a co-trustee along with it. So let me walk you through that. When someone gets a judgment against you, what happens is they get to step into your shoes and get to whatever assets that you can get to. And so let's say you got a couple $100,000, maybe $1 million in these trusts, and now there's been a judgment against you, and if you were the sole trustee and you could take the money out at any time without asking anybody else, the creditor protection is not as strong. But if we have an independent co-trustee, someone who's not related to you, can't be your spouse, and not anyone you can control, but someone who is an independent third party that you could say, and you could work with them, but when you got sued, you could say, you need to go talk to my co-trustee, and that's what the trust says, and they have to ask the co-trustee to make a distribution to the creditors. And normally, good luck getting those third-party co-trustees to distribute those assets for the creditors and predators of this world, because their job is to say no in those circumstances. So you need to understand the mechanics of it. There's a spectrum when it comes to creditor protection. Least amount of protection is you being the sole trustee of your own trust. More protection is you'll be a co-trustee with an independent co-trustee. The most protection is you're not even a trustee. You tell the creditors or predators of the world, go talk to that independent trustee for that. And so on the law firm side, there's things that we'll be documenting throughout the year, and that would be spelled out in your beneficiary inheritance member agreement that lays out the services that we offer to make sure that the assets in your trust are protected from the creditors and predators of this world. This has been Bobby Feisee, attorney with Insight Law. Thank you very much.